Hi, Brian.
Hi, Liz. Okay, I have 3 o'clock, so I'll go ahead and get started. And today's Get Smart class is on buying and selling when you've got an LLC client. That is those transactions involving LLCs. And I've written a primer for you guys to use. So I'd save that. I'm sure Liz will upload it to Elmo. And I'm going to kind of follow that and use that as a guide for the class. And so you should have gotten that email and have that on your own about 15 minutes or so ago. And so when we talk about an LLC, that the acronym stands for a limited liability company. It's not limited liability corporation, it's company. And it's a relatively new entity under the law. Historically, we had sole proprietorships. Many of you are that as agents. We have partnerships, although they're not used that much anymore, but two or more people go into business together and not having selected any other form, they're partners. And then of course we had a corporation. A limited liability company, an LLC, is really a hybrid between a partnership and a corporation. It really takes advantage, I should say, of kind of the best of parts of a partnership and the best parts of a corporation. It's really a terrific entity, not only for doing business as you guys do it, if you choose to do business as an entity and get that license, but buying and holding real estate and transacting any business. It has great tax advantages. It's easy and flexible. And so that's probably the most common entity you're going to run across these days, I think, buying and selling real estate. So because it's a bit of a hybrid between a partnership and a corporation, it has some unique features that affect us in the real estate world. So the first thing is, you see here on the screen, who owns an LLC? Well, it's easy to think about it in terms of the other entities. So in a partnership, obviously the partners are the owners. In a corporation, we know shareholders are the owners. Well, similar to both of those, the owners of an LLC are members. It's the equivalent term of partners and shareholders. They're members. And so that gives rise to the question whether you're doing the contract or we're later signing the deed or they're signing it. Who can sign for an LLC? Well, again, if we look back at partnership law, all partners have to sign for a partnership. Now, you can take steps to make a general partner. If you're a limited partnership, you can do a resolution of the partners, and you can do various things like that. But as a general proposition, everyone has to sign. Partners, that is. On the other side of the coin, a corporation, you don't have all the shareholders sign. Apple doesn't do business with having millions of people sign. Presidents, corporate officers have the authority to sign, both under the law and then typically under the bylaws that organize the corporation. So an LLC can be like both of those in that, as a general rule, like a partnership, all members of an LLC, that is, all owners, have to sign. That's the basic general rule. But by statute, that is by Virginia law, the members have the ability to designate a manager, and the manager is the functional equivalent of, say, a president. So if the LLC designates a manager, then the manager, assuming the manager's given the appropriate authority to buy and sell real estate, then the manager would be signing for the LLC, similar to the way a president signs for a corporation. And that really takes us to the next part of this, which is, okay, so what are the governing documents of an LLC? An LLC is formed, unlike a partnership where you can kind of just do it. An LLC has to formally be formed, and then we're going to talk about Virginia, with the Virginia State Corporation Commission. That's done by filing what are known as articles of organization. If the state corporation accepts what's been filed, and it's all in proper order, then the State Corporation Commission will issue what's known as a certificate of organization. And that's really like the charter, so to speak. It says you exist, LLC, under the law of Virginia. The LLC then typically operates under what's known as an operating agreement. And this is similar to the bylaws of a corporation. It's the written or a partnership agreement for a partnership. It's the spelling out in written form sort of the rules and regulations and owners and all of those kinds of things in connection with an LLC. So those are the three basic things: articles of organization, certificate of organization, and operating agreement. And as we're going to see in the next section, all of those are going to need to be produced when an LLC is either buying or selling. And your client should have those. Quite often they don't, but they should have them. Otherwise, we're all scrambling to try and get those things in order near closing. So I wrote First American, which is the company that we Lytle Title is an agent for, and asked the underwriter, okay, tell me, send me your requirements for a title binder when an LLC is either buying or selling. And so that's what these next two sections. So when an LLC sells, for example, and it's true whether it's Fidelity or Stewart or Chicago or First American, they all want the same thing. The first thing is they're going to want is copies of the articles of organization. They're going to want to see the operating agreement, if there is one. Now, let me take a moment. The law doesn't actually require an operating agreement. If an LLC does not have an operating agreement, then in essence, the General Assembly has written one. The General Assembly, through law, through the Virginia Code, has specified all the rules and regulations that might otherwise be covered in an operating agreement. For what it's worth, if you have an LLC or whatever, you should have an operating agreement. Nevertheless, this says if there is one, it's got to be provided. I've run into situations before where I can, tell the other side or a lender or whomever till I'm blue in the face that an operating agreement is not required, but it's always a problem. If there is no operating agreement, according to First American at least, then they will accept an affidavit saying there is no operating agreement. The third thing they're going to require is the certificate of organization, which is what we talked about up here. And then one thing I didn't mention is a certificate of fact. And that's because that's not really an operational instrument of the LLC. It's something that the Virginia State Corporation Commission issues, certifying as an official record that the LLC is in existence, in good standing with the State Corporation Commission, and is valid and authorized to do business. So that's what the title company is going to want when if you've got an LLC seller, the buyer side on the deal, the title insurer, they're going to say, we need all of these things. And you'll see down here where the underwriter is making a special note that all the members of the LLC, as I explained, need to sign, or a managing member, but that's got to be designated in the operating agreement. In other words, you can't have somebody in an LLC say, well, yeah, we've got a couple owners, my wife and my son, but I'm in charge and I can sign. That isn't going to work. That's got to be in a writing signed by all the members, either in the operating agreement or we can do it by resolution. Going on down, what is required when an LLC is buying? You got an investor and they're buying in an LLC. It's really the exact same stuff. You still got to have articles of organization, still got to have an operating agreement, still got to have the certificate of organization, still got to have the certificate of fact. So if you look at those two paragraphs, they're really identical. And that's because all of those things are required, whether the LLC is buying or selling. I suppose you could get a cash deal where an LLC investor is buying property, and if they're not getting title insurance, then no one in particular is going to say, hey, you need to provide this stuff. And I know, cash or investors quite often pay cash, and they're quite often doing it in an LLC. If they're smart, they're still going to get owner's title insurance, and they can't get owner's title insurance unless they supply all those things. So what I did was I went ahead and rearranged those requirements and sort of a sample email that you guys could just cut and paste early on in your transaction, or when you take the listing, or when you're working with a buyer. The point is sooner rather than later. And you can see how, and you can use your own language, but I think it's fine if you just cut and paste. John or client, whatever the name is, just wanted to give you a heads up that this is what's going to be needed, and go ahead and start working on it. Those of you who've worked with LLCs probably would not be surprised because you've experienced it, that quite often the clients just don't have this stuff together. They don't know where to get it. And maybe they formed the thing themselves, and as a result, they're not going to have all the right documents. So, because they don't really follow through and do it the way, for example, a lawyer, if I'm doing an LLC, I make sure all of these things are done. So anyways, a sample email to your buyer client, a sample email to your seller client. You're welcome to cut and paste that. Where can things go wrong? Well, so typically, as I just mentioned, the client doesn't have all the documents. And so if you think about it, from a buyer side standpoint, the way that process works is you get the contract, you're ordering the title work sent to the underwriter for the title insurance company, and then the underwriter sends us the binder, also called a commitment, and then we see in there, or the Lytle Title staff sees in there everything that's required because it's an LLC. That doesn't happen very early in the process. It's usually happening near the end. So, typically what goes wrong is that the client just doesn't have all the documents. We're near the closing, and everybody's scrambling trying to get them or create them. For example, if there was no operating agreement and we need one. A second problem that you guys are really not anybody on this Zoom call, because I know you guys are the good agents. It's all the agents not on the Zoom call or training who make this mistake. And that is, they don't write the correct, I'm having a hard time highlighting with my huge cursor. They don't write the correct name of the LLC. Yeah, it may be, Bob's Custom Power Wash, whatever. And that's all they write. They don't indicate that it's an LLC or distinguish it from a, excuse me, corporation. And so from the get-go, you haven't really listed the proper party. And then secondly, I just went through the chain of events to get to closing. How are we supposed to know it's an LLC or a corporation or a partnership or sole proprietorship? So get the correct name and use that on the contract. The very worst thing that happens is, this huge cursor's a problem. Each year, an LLC or a corporation for that matter has to pay an annual fee to the State Corporation Commission. They have to file an annual report. If they don't do that, their legal existence is suspended and then eventually terminated and then eventually purged by the State Corporation Commission, which means they're not a legal entity and we can't close. We're pretty good about fixing that, and there's lots of mechanisms to do it. But again, finding that out the day or two before closing is not a recipe for a smooth closing. So that's typically the worst that happens. And we try and work through it. Now, if you really want to be a great agent, I'm going to show you how to check on your client LLC and figure that out. So let me, if I can do this, let me switch over. All right, so hopefully you guys have got my Google, hold on, let me move it over towards the camera. All right, so hopefully you've got my.
We can see it. You
got it? Okay, I'm getting a weird look on my end. So anyways, all you need to really do is type Virginia SEC entity. God, I'm a terrible typist. But anyway, so you see that pops up. And click on the link. You get the State Corporation Commission's website. Let's just type in Liz Moore.
I think we're still stuck at Google.
I'm sorry, what?
I still only just see your Google search screen.
Yeah, that's all we're seeing.
All right, let me try this again.
You have two Google screens up and you're on the wrong one or a different one.
There
Can
we
you
go.
see it now?
Oh, good. Yep.
All right, let me go back. All right, so I typed in Virginia SCC entity search, and you've got the link on the primer, by the way, in case, you don't have to write all this down. Then you just click on that, and then I'm going to search for Liz Moore. Liz Moore Associates comes up. I click on the little icon, and then, in the context of what we're talking about, and this is good because I would really be in a lot of trouble if the company was not active. But you can see we are in fact active. The other curious thing about this is it always lists the most important person in the company. Well, okay, maybe that's not true, but I happen to be the registered agent for the LLC. So look, this is how you can get the exact name of the client you're dealing with, so you know how to write it on the contract appropriately. You can verify that they're active. If this says, terminated, purged, suspended, or something like that, that's when you guys, you're going to need to let your client know, and maybe you reach out to me. So that's really that. It's pretty easy. Okay, now let me get back to my primer. Okay, so that's the link here. That may be an active link. You may be able to just control and click on it, and it'll take you where you need to go. It looks like it's a embedded URL in the primer. And then I went ahead and showed you how people sign. And so, for example, now these are formal signature blocks. The way I would do it on the contract I draft or a deed or something like that. But this just gives you an example of that. And so it's, it's the entity name by, me, comma, manager, if it's member managed. If there's more than one member, remember I said all of them need to sign. So, you're signing as MBR, or you can write out member, and then the other member signs. And if you had more than two, you just keep that on, keep going. And then you can have a single member LLC, which is kind of a cool thing, unlike a partnership. And so you would just designate down here, you're the sole member, that's hard to read my handwriting, SOLE, MBR. For you guys, you've already written the contract with the name of the LLC at the beginning of the contract. And then you've got signature lines, and it's really hard to do this kind of stuff, the signature blocks, especially when they're signing electronically. So they're still going to sign in a representative capacity. This would be, if you're, I know you guys are all whizzes with electronic signatures, but you're doing something like this for the electronic signature. You're showing the representative capacity so that when they sign, that comes up. Manager, Brian Lytle, manager would be the electronic signature. And so that's what's talking about here. I promised you guys a short and sweet class. So right now I'll just open it up to any questions. I don't have the chat, so somebody can.
I have
Brian?
a question.
Yeah.
So if we don't sign like that, if you just signed Brian Lytle and you didn't put me there, how big a problem is that on a contract?
Oh, it's horrible. You probably lose your license. The contract's not enforceable. Well, considering that 999 out of every 1,000 contracts we've ever done don't have that. It's clearly not a crisis. Everybody's going to if it's in the in the first page and in the name block, it's correct. Then it's really understood that you're, it should be clear that you're signing in a representative capacity, but if things were to go awry, the first thing a clever lawyer is going to do is try and claim that there was there's no liability protection because it wasn't representative. I'm more not concerned about that. I'm more concerned about making sure that everybody who needs to sign should be signing. And I think the biggest mistake there would be there really is no manager, and so all the members should be signing. But obviously we don't, our clients aren't getting sued every day. This sort of works its way through the system. It can make for bad closings, but one way or the other, we always help and we get it done. I would just prefer, I want you guys are great agents, and I want you to be the greatest agents. And okay, well, you're that, even greater than greatest. And so part of that is really knowing what you're doing and paying attention to detail, dotting all your I's and crossing your T's. And as you can see, this isn't something that's very hard. And then of course, you've got the primer now, and you can share it with your clients if you want. There's nothing wrong with that. You can link them to the Get Smart video once it gets up. Let's just make sure that we're doing it the best we can at making sure everybody that needs to sign signs. So.
Brian?
Yes.
I normally, when I do the contract, I designate, I put in the provisions, so-and-so will be the managing or the authorized signing party for whatever LLC's name. Is that enough to not now have to put the big long signature?
Yeah, Leanne, I think that's a great way to handle it. It makes it clear that they're signing in a representative capacity. Again, the only thing I would caution is, if it's a multi-member LLC, you got to make sure that that person does have the authority to sign for the LLC. Really well-established LLCs do have managers. They're named in the operating agreement. We give them the specific power to deal with real estate, and so it's not a problem. But when you get a typical, again, LLC formed by people on their own, or they're not paying attention to their paperwork, then quite often they think they've got the authority to sign when technically they don't. And contracts tend to work themselves out because the buyer wants to buy and the seller wants to sell. But I can tell you on the deed, as you can see by First American's requirements, we really, really pay attention to that because we've got to make sure that deed is valid. So. Any other questions?
There's some in the chat. Cole said define registered agent, possible roles, actions executed by this agent.
Okay, so in Virginia, in order to have an entity, whether it's a corporation or an LLC, you have to have someone serve as a registered agent. And that's simply a person that the company has designated as being authorized to get service of process and other official service in litigation and from the State Corporation Commission. So for example, if Lismore and Associates got sued or a subpoena is issued, it's quite common. No, this has never happened, of course, but it would be quite common for them to serve me as the registered agent of the LLC. So, Cole, registered agents don't have any role or authority or ownership or anything like that in a corporation or an LLC. They're merely the designated person to receive official process, if that makes sense. And there are restrictions on who, you either got to be a member of the Virginia State Bar or an officer or owner of the company. It can't just be in some random third party. So I can't pull up the chats. Jackie, can you help me with those?
Yes, Cole also, he said, please. And then his second question is, won't most lenders, buyers, and sellers require signatures of all members with real estate transactions in addition to an app agreement, authorized manager of operations, or even LLC officer?
Cole, they might initially want the signatures of all members, but that's not really legally required. If we were to take a look at the primer again, even First American's requirements say that if the operating agreement designates a manager, and it's demonstrated that the manager has the authority in the operating agreement, for example, to sell real estate, then that's really all that's legally required. If you don't have that, you can do a resolution signed by all the members authorizing, so it's in effect like a power of attorney. So I can't tell you that some buyer sides and title insurers won't go with the default. We insist everybody sign, but that's not really legally required as long as the LLC has all the I's dotted and T's crossed. We can usually work through that. Jackie, I've got the chat now. So Valerie's asking, purchaser would be in the name of an LLC, and then the signature block would be name of LLC, and then name, not general. Well,
Sorry.
LLCs, Valerie, don't really have general managers. We just call them a manager. And so if I understand your question, I'm really, okay, I may have thrown you for a loop with my normal signature blocks. The contract's going to have the purchasers would be the name of the LLC, and then down where you sign in the contract, if a manager has the authority to sign, then it would be Lytle title. Well, it would just be Brian D. Lytle, comma, manager, because the way I'm looking at that is the contract sort of sets the top part of the signature block, and then the actual signature line, the person signs the correct way and shows what capacity they're signing, whether that's manager, member, sole member, all of those examples I gave. And if you had a multi-member LLC, then each one of them is going to sign their name, comma, member. Is that the
I
answer?
think she's confused because you've got Lytle title and escrow typed on top of that.
Right. Well, okay, let me go back down there. Yeah, so this is the way in deeds and contracts that we draft, we do the signature block. We type the name of the company because that's really who's signing. And then we show the representative capacity by, and then this is where I sign, and then we identify me. So what I'm saying is in the contract, I mean, if you guys have the room to do it, great, do it exactly the way I've done it here. But if you don't, then what you're doing is you're not retyping this part of it. And they're signing on your contract signature line, this part right here, my signature, comma, manager, member, sole member, whatever. And then it's nice to write underneath of that to show what that name is and the capacity. Does that get at it, Liz, Valerie?
I think so.
Yeah, I guess if some, well, I'll make a note, and what I will do is follow this up with some samples on one of the association contracts that we use. I think that would probably help everybody. Would that work?
Yes.
Okay. All right, so I'll do that, and I may even add it to the primer so it's there, because I can see how that would be confusing based on how you guys work. I don't see any more in the chat room. Does anybody else have any other questions? All right, well, let's see. So, dang it, 30 minutes. I was hoping for 15 or 20. Anyways, I appreciate you guys joining me this afternoon. I hope you find this useful. And, again, like always, I don't necessarily expect everybody to always remember each of the little details here. So if something comes up and you're not sure, pull out the primer, ask Liz, Donna, Tanya, Sandra. I'm sure they can help you, but if they can't, or you want to just email me directly, I'm happy to help. So thanks, guys. Everybody have a great day.
Thank you.
Thank you, Brian.